For okay. It's up to you. I mean, no, okay. I understand. Good morning, everyone. Today's Friday, March 17th, 2023. This is voting list number 13. We're going to start off the voting session with Senate Bill 292, and that's Jamie.
Just a recap from yesterday, Senate Bill 292 does a number of things. First, it alters procedures that law enforcement officers and a court must follow when there's reason to believe that a child who has been detained is a victim of sex trafficking or a victim of human trafficking. The bill also prohibits the criminal prosecution of a juvenile or a juvenile proceeding against a minor for a qualifying offense, a violation, which are specified offenses defined in the bill, or an offense under 31102 of the criminal article, which is human trafficking, or excuse me, sex trafficking, if the minor committed the underlying act is a direct result of sex trafficking. The bill also adds offenses to the list of qualifying offenses for which a person may file a motion to vacate a judgment if that person's participation was a direct result of being a victim of human trafficking. There's one amendment in your voting packet. The amendment affects language on page 6 of the bill. On that page, there's a provision where a court is required to dismiss a case if the court finds that the child is a victim of sex trafficking or human trafficking and committed the qualifying offense, violation, or human trafficking offense is a direct result of being a victim of sex trafficking or human trafficking. This amends it to say that instead of dismissing the case, the court would just dismiss the qualifying offense, violation, or human trafficking offense.
You're gonna move your amendment?
Thank you, Mr. Chairman. This amendment is just clarifying, and it came to me from the advocates who are okay with the amendment, and so I would move the amendment.
Is that okay being recorded in favor of the amendment? Okay.
Yeah, so under the bill as drafted, the court would be required to dismiss the entire case against the minor. What this says is that instead of dismissing the case, the court would be dismissing those offenses, the qualifying offense, violation, or human trafficking offense.
Is everyone okay being recorded in the affirmative? Do we need a roll call?
Explain my vote.
Sure.
So I did take some time and reread to refresh my memory about this bill. It's been around for a long time, but again, we've had so many similar things. I just couldn't specifically remember the details. I have no opposition to the bill, but I do have feelings about the process. And also kind of the way that there didn't appear to be much tolerance for any questions that I had yesterday was a little troubling to me. I do have questions, and I know that nobody cares, but I've actually represented children that are trafficked. I've represented children that are automatically charged as adults. I've represented children that are lead poisoned. I've represented children that have developmental disabilities. I've represented children that come from abuse and neglect. I represented children that are lured and coerced into gang activity. And fundamentally, there's no real difference between the trauma and the fact that very rarely are there circumstances such that it could be argued that they were acting on their own, fully aware of the consequences of their actions, and that they should be prosecuted. In the two more recent cases that I've represented children that are trafficked, there was no way in the entire world, once it was discovered and discussed with the prosecutor, that the prosecutor was going to prosecute this child. I don't believe, because you even see the state's attorneys here agreeing with this bill, that this is a thing where we are really prosecuting these children. But the issue that I have, and even if you can hear it in my voice, the fact that we take one category of traumatized children and ignore and demonize all of the others, And we're talking about Black children. And the fact that this is a bill that is a feel-good bill, I don't know in practical reality that it really does a whole lot, because I honestly don't believe in Maryland these cases are being prosecuted. I know that what we usually do is we do a mutual postponement for the child to go into a treatment or a program and get the services they need. And then once that's done, the case is dismissed anyway. That's been standard what I've done. Maybe it's not done across the state, but that's where it's done in Baltimore City and County where I've done the cases. And it defies logic to me that we only recognize this as this group of children as children that we need to save from the criminal justice system. For 13 years, there's been science, there's been advocates that have come here and explained the trauma that happens when we charge children as adults and they all wind up either being sent back to the juvenile system after they've been in the adult system, the lack of services they receive if they're in the adult system. And it's gone really with no compassion, no understanding, and no care. If a child that was trafficked was automatically charged as an adult, I'm pretty sure that we would have a problem with that. But we don't care about that child that's lead poisoned or neglected or just coerced into a gang or just has horrible parenting and horrible circumstances that is in that situation. And so I take great issue with the fact that we have this selective care. There is no fundamental difference when I represent a child that is trafficked versus a child that comes from all of these other traumas. Yet there are those here that would take those other children and demonize them, criminalize them, and put them in prison for life. What if a trafficked child was involved in a felony and that felony wound up having a death occur? And so felony murder. Would we suddenly have sympathy for this idea that felony murder can be very unfair? I don't know. So I think it's important. I appreciate the time for me to explain how I feel. It's outrageous. It's outrageous that we only see this particular group of minors as victims and children, and it's not okay. And last year, we passed a bill that said we got to save children from marriage, but we still can't save other children from the criminal justice system. I think there's something fundamentally wrong with this mentality and this lack of regard for Black children in this body. And I appreciate the time for being heard. Thank you.
I just want to say that first, well said. Secondly, there is an equity that is always overlooked. I agree with you 100%. I have problems with this bill because of that I'm going to vote for the bill because this bill is not going to save the situation we're talking about one way or the other. But I would employ all of us to at least think about how we can be much more sensitive and turn around a problem that we've had forever. These Black children are no different than the others. They're not monsters. I was there and I understand I'm not a monster. I've done some things, but we have to look at it with a sense of equity. I agree with you. I was going to vote yesterday. I made my mind up to vote a different way. I'm going to support the bill, but I understand very well and very well said.
Sorry, I want to echo, I think, a lot of the concern and compassion for children that was shared by Senator Carter. I agree with her that we need to do better for all children. And I want to state that really clearly because I am hopeful that as we move forward as a General Assembly, we are going to be moving forward on lots and lots of proposals that help all children, because I think it's incredibly important. And I join you in that, and Senator Muse. But I do want to say that the children that this legislation is going to help, and the compassion that are shown that this legislation shows for children, 71% of these children are children of color. So I don't want to lose sight of them as well. 71% of the children who've been identified as victims and trafficking survivors in Maryland. I think it's 111 of the 156 children. So reflective of the population in Maryland. And I think it's a really important bill. I'm glad to see us moving forward with this, but I also absolutely look forward to partnering on other proposals that address the issues that were raised by Senator Carter.
No, echo the sentiments. I appreciate Senator Carter and your ideological consistency, and I couldn't be more in step with what you just said. And I also appreciate the other members for chiming in. It's a high level of debate and quality of discussions, especially at 10 o'clock in the morning on a Friday after a long week in the midst of a busy session. So with that, there's been a motion for a favorable. It's been seconded. We're going to do a roll call.
Vice Chair Waldstraker,
Yes.
Senator Sidnor,
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Washington,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Yes.
Chairman Smith.
Yes. And 11-0. All right, Josh, you're up with Senate Bill 383.
Senate Bill 383 authorizes a court in a custody or visitation proceeding to require a party to provide advance written notice to the court or the other party of the intent to travel outside the United States with the child. The bill also authorizes a court to order abduction prevention measures in a proceeding if the court finds that the evidence establishes a credible risk of abduction of the child and establishes procedures by which a party or another entity as specified may file a petition. There is an amendment in your packet. It's number 213923/1. This amendment conforms the bill to the House cross-file by striking the notice provision of the bill and conforming the bill to the Uniform Child Abduction Prevention Act. Yeah, that is the amendment.
Give members a second to Senator McKay. Go ahead. All right, you want to adopt the amendment?
Yeah, move the amendment.
Can we adopt the amendment so we have something to work off of? Is everyone okay with that? All right. Now the bill's before you as amended. Discussion.
Is there, I think the last bill had some sort of a time period. Is there still, I mean, is that part of this amended bill?
I mean, the time periods generally be what, within which the custody proceeding is being litigated by the court.
Thank you.
I remember reading the judiciary's opposition, which is not to the purpose or intent of the bill, but just in the drafting of it. And, that language is not clear and could lead to some unintended consequences. So did what the amendments we just adopt, which is to conform to the House, does that help address the judiciary's concern about really bill drafting and language?
Yeah, I'm not sure about the specific points, but what the amendments do is that they adopt the Uniform Act with only minor technical changes. So that's an act. I know the act exists under federal law and a number of states have adopted it as well.
So what you're saying is our bill just didn't follow the Uniform Act, the House did. Now we're conforming it. And because it's a Uniform Act, which has been around now and courts have had a chance to review it and enforce it, that's what we've just done.
Yeah, I believe that the original draft was based on the Model Act, but had some substantive changes, and essentially the only changes now are technical in nature.
All right, thank you, Josh.
I was just going to answer that. It is my understanding that the House did work with those in opposition to conform it. So it was, so. Thank you.
Senator Sidnor.
Again, this is a whole lot of change, and I just want to make certain that I'm understanding. The original bill, I guess, would have helped address if there was some sort of, maybe some sort. I remember testimony about maybe custody battles and one parent absconding off with the child, their child, but not having the right or the custody to have the child. And for some reason, again, I remember something about there was a distance that a parent could take a child without, I guess, triggering some sort of a court response. Is that, I mean, again, how is that all addressed in this?
I think you may be referring to another bill the committee passed, which dealt with expedited hearings when someone is relocating. So this bill
Okay,
primarily deals with travel outside the country.
thank you. Help me.
So essentially what the bill does is allow a court to hear evidence that there is a risk of child abduction and to order certain safeguards to try to prevent a parent from abducting a child to another country.
We've adopted the amendments already. So I would like to move the bill. I love it.
I mean, I wasn't done with my questions, but I hear you. Yeah, I just want to know what, I mean, how many times does this, do we know the numbers of how often this happens? And if I'm a parent that wants to take my child out the country, we're in an agreed custody and agreement, and I take them out 2 weeks from now, this says within 90 days. I'm trying to get answers too, Brenna.
What's the process now? What do
Right,
you have to
yeah,
do?
right.
Asking like how, what,
Process work. I'm a parent, we're in a custody agreement. I want to take my child out the country in the next 2 weeks or so.
so the other party who's concerned about a potential abduction would go to the court and present evidence that they think indicates a risk that an abduction will occur. And if you go on page 7 of 7 of the reprint, you can see, the things that the court can consider as evidence of that. And then I think later in the bill, you'll see if the court finds that there is, a credible threat of an abduction, they can order certain safeguards. So that, if you go to the unnumbered page after 7 of 7 at the bottom of the page there in the new section 9.7-108, you can see, the court can enter an order that includes and then going over to the next page in the new subsection C, these are the things that the court can include, like an imposition of travel restrictions that require the party traveling to provide the other parent with certain information, such as the itinerary, prohibitions on, on removing the child from the United States without permission from the court. And, those kinds of conditions on international travel could be imposed by the court.
And you said this language, I think Senator McKay said that the House adopted this.
The
language
House,
already?
I think the bill is on third reading now with this amendment.
With this amendment, okay.
Model code out, like I don't.
It's the, I think it's the model or the Uniform Act. Can't remember exactly what it's called, but there is a national
They
organization.
testified remotely.
They did,
Yeah.
yes.
Senator Kelly, or Senator Washington, are you done yet, or just to make sure?
No, go ahead.
Okay, Senator Kelly.
Okay, so thank you. So I think if I understand this correctly, right, this is going to solve the problem. If you have joint custody and everything's going great, it's fine, and you continue to travel as appropriate, and maybe you have 2255, or maybe you have week on, week off. It doesn't matter. You partner with your co-parent to figure out when they can travel, and it's all mutually agreed to. You're golden. if you're living in fear, like some people are, that your co-parent might abduct the child, that's when this comes into play, and you can go before the court because you are living in terror that your co-parent might take their 2 days and instead abscond with the child to a country that you can't get the child back from, right? So that's the purpose of this bill. Sounds like a great bill. Thank you.
Like,
That they're considering, like whether they're going to a country that doesn't have an extradition treaty, whether they're going to a country that's not a member of the Hague, whether they have lots of deployment, whether they threaten to abduct the child.
I mean, I think the defenses would be to try to argue why those things are not, there's another explanation for those things. And, the court would have to find that, the evidence ultimately supports the conclusion that there's a threat of abduction. And there is, so on, let's see, the unnumbered page after 7 of 7, down near the bottom in the new subsection B there, the court shall consider any evidence that the respondent believed in good faith that the conduct was necessary to avoid imminent harm to the child or respondent. So that would be one potential defense.
Sort of,
So this is from the Uniform Child Abduction Prevention Act.
Remember those people that came in, they typed in, they came on 2 different issues. One was this one, and then one was the bill we passed a couple weeks ago. But they're same organization, both from Chicago.
Right, the organization that writes most of these uniform acts. The Model Law Commission, I think it is.
Yeah, this is the standard language.
Their goal is to have every state.
Let me look that up.
it's just a big change to see this just now and have to take a vote on it. But
But it's the amendments. Oh, sorry. Am I correct that the amendments all reflect, as Senator James suggested, reflect the suggestions that are made in the favorable with amendment testimony? So that was all available at the hearing, right?
Correct. And 14 states and the District of Columbia have adopted the Model Act.
Okay, great.
This isn't the first year that this has been presented. This is like the third year. Trying to get everyone together. I think we should move the bill.
Second.
All right, bill passes unanimously.
Good job, Mike.
Bill 746.
Senate Bill 746 requires the owner of a manufactured housing community to comply with certain requirements when selling the manufactured housing community, including providing the homeowner the opportunity to purchase the manufactured housing community. There is an amendment in your packets. Amendment number 1 is technical.
I need you to order the copy.
Amendment number 2 alters requirements relating to relocation plans for mobile home parks. And amendment number 3 does several things. 1, it requires a homeowners organization to comprise homeowners who lease or rent at least 75% of the lots in the manufactured housing community. It adds additional transactions that are excluded from the applicability of the bill. It provides that a sale covered by the provisions of the bill may proceed without opportunity for a homeowners organization to make an offer if the purchaser files an affidavit in the land records affirming certain commitments. It alters the requirements pertaining to notice of an offer the community owner has conditionally accepted if such notice is required. It limits liability of a community owner to a party to a real estate transaction for certain violations. Alters the calculation of homeowners necessary to commit to purchasing the manufactured housing community. It alters the timeline for a homeowner's organization to obtain financing and close on the purchase of the manufactured housing community, and states that the community owner has complied with its obligations if these conditions are not met, and requires the Department of Housing and Community Development to maintain a list of certain organizations on its website. It requires a community owner or purchaser who files a certain affidavit in the land records to provide notice of the affidavit to each homeowner and post a copy of the affidavit in a public area of the manufactured housing community. And it establishes a penalty for a purchaser of a manufactured housing community that acts in conflict with certain commitments affirmed in an affidavit recorded in the land records. This was cross-filed with HB 23, and those amendments were conforming with the House amendments.
So we'll move the amendments first and we'll speak on it. Is everyone okay adopting the amendments? Sure. All right. Senator Washington.
I was looking at my packet. Did we get that amendment?
It's been, so here's the thing.
I was trying to look for it and I didn't.
No, yeah, it's exactly right. I did the same thing. You're way more organized than I am, so here you go.
All right. I mean, I'm not trying to hold
No.
this guy's bill up, but I was trying to find the amendments and I
It's the same. I thought I gave them.
in this bill.
I thought I handed those out, but they're exactly the same as the House amendments.
Yep, but none of us have the access to the House amendments at this moment, but I saw something interesting in this bill, which was if the property is sold, then there's a period of time where the rents cannot be increased. Is that still in a bill as amended?
No, it can't go up by more than 10%.
Here.
Right, right, but it's like,
So it doesn't say it can't be increased, just says they can't.
it's a cap on the increase.
Yeah.
Correct. Do we do that for any other place in the state where we cap rents that we do from the state's perspective? I know local governments do this sometimes where they cap rent increases at a certain point. And if we're getting into that realm of like capping rents, I would love that, by the way.
I was wondering where you're going.
I mean, if we're gonna do it for these manufactured communities, I mean, I'm sure there's other communities that would love for.
It's actually only if it's sold.
If it's sold. I hear you, but there's a lot of properties that are multifamily dwelling units that are sold. And then the rent increases because that property owner wants to, jack up their rent to get their money back. And so I'm concerned that we're doing it for this one type of property and not others where we have affordable housing shortages across the country, across the state at least. So I asked if that's still in there, if that's something that we continue, if that's something that we're doing, that's something that this committee is committed to doing in the future. Mr. Chairman. I'm just seeing the amendment now. And so, because I was intrigued by that. I love that. I would vote for something like that. But I want to make sure that we're being consistent and it's equitable across different types of properties that are sold.
I'm looking on page 3, I think, of the amendment. So I'm not familiar with this process. Well, let me just ask you, is this some kind of uniform code? Is this bill similar to some uniform code that's out there?
I don't know if there's a uniform code for it. There was an advocate that had worked with the House sponsor and came up with these amendments. I'm not sure if it's uniform though.
I'm hearing, thank you, Senator Folden. Either one of you. So this language has been, and this concept and language has been adopted in other states.
That's where it came from.
Yeah, what would that be, Senator Folden?
What other states?
Mm-hmm.
The primary bill sponsor in the House You want to come up, Bill? Thank you.
Thank you. Yeah, so some of the language is reflective of states like New Jersey that have had kind of a period of, and I'm not exactly sure which amendment you were talking about, but
Was it, I think this amendment that we're looking at now informs, did you say this amendment, I'm sorry. 273-525, am I looking at the right amendment? Okay, and that's
Yeah.
the amendment that
Yeah.
Bill,
yeah.
right.
So, yeah, it gives, so the bill seeks to do a period where it gives a tenant group, if all the tenants in that park want to purchase it, that right. If a purchaser of that mobile home park refuses to commit to keeping it a mobile home park for the next 5 years. So the big threat that I think most mobile home parks face is that you have investors coming in, purchasing the property, and then as in a way to actually change the use of that entire property, they jack up rents and don't invest in the property. And then if they do a change of use in terms of zoning, and then the property becomes a, mixed use development, could be something else.
Right. I think my question, thank you for that, but my question was, is this language or the House bill, which you are probably, is that modeled on other states? I heard New
There-
Jersey.
Bits and pieces reflect different, I guess, steps that other places have taken.
And do you know whether there has been any challenge to this sort of suppressing the value of the property? If I understand the bill right, if all the homeowners in a mobile home band together and notify, probably kind of officially, the owner, hey, we would like the right to purchase this, then the owner is mandated to accept or work with that proposal?
So the way the bill would work is, let's assume someone doesn't, the owner wants to put it on the market. They get a private bidder who comes in, an investor comes in. That private investor says, you know what, I'm not going to commit. I'm not going to put an affidavit in the land record. I'm not going to commit to keeping it as a mobile home park for the next 5 years. At that point, there would be a trigger in the bill that basically says, hey, homeowners, do you want to get together, submit an offer? And all that the bill would really do is give them time to do that, put a bid in. If that bid is a good faith purchase offer, consistent with the offer that the owner was considering accepting from the private investor, they would be able to move forward.
Why did you choose 5 years? Is that, you said the private bidder has to commit to keeping it as a mobile home park for 5 years?
I think we thought that was a good commitment of time to discourage an investor who's going to come in and just try to flip the property.
My concern is this is sort of coming up close to the line to like a right of first refusal, which are just favored by the courts because they suppress the value of the property. They suppress private enterprise and business. So that's my concern, that if we pass this, then mobile home owners could argue that this process we've created, and bidders are going to know about this. They're going to shy away or come in with much lower bids saying, hey, look, I'm going to discount what I'm going to pay you because I know I can get caught up in this mechanism here, or there's some uncertainty about this mechanism and whether I could proceed. And in addition, you're asking a private owner and really a private buyer to to make a commitment on what they're going to do with their land. And that worries me in terms of interfering with just the right to do what you want on your land and whether that would even stand up in court.
Yeah, I think for the way the bill's set up, there is no trouble that a person who wants to sell a mobile home park will have in terms of attracting investors who actually are in the business of running mobile home parks. But you're right, it could discourage someone from Wall Street who decides they want to come in, buy it, use it, change it for a different purpose, displace all the folks there. And I think so. I do think there is that is part of the intent of the bill, which is to say, look, we want to encourage mobile home park owners to continue to operate these as mobile home parks, given that this is one of the most affordable housing choices that folks have.
I'm not
Yeah.
suggesting that we don't have issues about affordable housing,
Yeah.
nor am I against trying to help
Yeah.
with that. But my concern is, and let me just give you an example. You have a mobile home park, and it's in an area that over the last 10 or 20 years has been changing and changing and changing. And it makes no sense for this owner, one, to continue this park. And really, he needs to sort of, for a lot of reasons, it's challenging to even upkeep it because of the changing circumstances around it. So in that sense, even if he loved his mobile home park and wished he could keep doing it, it doesn't make sense for him or any prospective buyer to try to continue it as that. And so there's a lot of circumstances around which the zoning
Right.
would be changed, right? And usually zoning is changed systematically and hopefully thoughtfully because of what's happening in reality on the ground, or there's public policy about this is a growth area we want, this is a conservation area, this is where we want residential. So there's a lot of factors outside the control of any mobile homeowner as to whether or not he can or should, keep it as such. So I guess this bill would kind of run up contrary to that idea.
Well, it doesn't mandate that you've got to take the resident offer. So it's not a true right of first refusal in that sense. They would have to provide an offer that matches whatever the private investor's going to match. So they would have to get 75% of the residents to agree that they would want to go that route. So I think it's a step, at least a couple steps short of a true right of first refusal. But it opens up options and provides an incentive for these parks to continue to be purchased by folks who are going to continue.
But just so I'm clear, if the homeowners bandy together and say they want to do this, the owner of the park has to
Consider it.
Yeah, so that's pretty close to a right of first refusal. Now, how long do the group of homeowners have to, make, I understand they're going to get together and they're going to try to match the price from the other offer, the other buyer. How long of a period do they have to work that through?
So under the amendments, they would have basically 60 days in order to make a decision about whether they wanted to move forward. Then that kicks in another period for them to essentially pull financing together. So 60 days, they would have to figure out if they can band together, if they have consent with other parties in order to meet whatever offers coming in.
So they got to close the deal in 60 days?
No, they'd have to close the deal in 100 and
Probably 120 days.
yeah.
Last question, for now, anyway. Because I wanted to understand the bill before I asked a question about the actual language. So on page 3, I'm just not familiar with, hold on. It says you have to develop the the owner has to develop a plan for relocating and in a budget reflecting the amount of relocation assistance allocated by the mobile home park owner to be given to each household. So I just, as I'm not familiar with a relocation assistance, is that something that the owner of the park has to come up with out of pocket, or is that something else?
Yeah, that's been in the law for quite a long time. And it's basically if there is going to be a mobile home owner is going to sell it. So they're going to displace the residents in that community. They've been required under Maryland law to have a kind of a relocation assistance that they would give.
So the owner comes up with the money. How does the amount of money determined? Is that
Based on their
really short
rents.
answer? Because I've asked a lot.
Yeah,
of questions.
based on their rents, their
Huh?
current rents. That
So
they
what, you
pay.
give them like a month's rent or a couple
Yeah,
months rent?
it's basically 10 months rent, something like that.
Thank you.
Yeah.
Thank you.
Shoot. Thank you. Thank you, Mr. Chairman. I do have a my questions weren't rhetorical earlier. I was really asking if there's anywhere in the state, if there's state law code where we cap rents for properties that are actually being sold, that have been sold to someone. You don't think what?
Answer to that question.
Yeah, I know.
We can do the
government-
research. We can get the answer to that one.
Yeah, I mean, that'd be great to have, just so I can be able to make sure we have it right, because I understand that, you know, you and I, Mr. Chairman, have the purple line in our district where affordable housing is a big issue, and capping rents will be perfect for those folks who want to be there. But also, I think Senator James is getting to a great point of rights of first refusal here in this bill, which is great because both of our county, Montgomery and Prince George's County, have it, but we don't do it for tenants that live in those properties where they can actually purchase property and band together. I think that sounds awesome. If they wanted to do it in a co-op, I have a co-op in my district where they banded together and actually own the properties together. And so this is what that sounds like. And I would love for this to be available to those other tenants as well, if we're going to move a bill like this, to be able to do that. And I would like to add an amendment that would add just the Purple Line corridor as a pilot program. If we're just doing manufacturing, if we're doing manufactured property homes, I would like to add an amendment that allows for the Purple Line within a half-mile radius of a Purple Line station to be able to, those tenants that are in those buildings to be able to purchase their property if they wanted to. So I would like, those are my questions. I do want to have answers to those questions. I like the way the bill is going, but I don't like the equity issue in it, that it doesn't allow for other people who are experiencing displacement, this tool at their advantage. So thank you.
Thank you, sir. So to answer your question, Senator, while it may not be actually sold, but we do have some precedent in homes that are owned by a particular person and receiving state grants and having caps on rentals when it comes to landlords and those type of things. So the whole home act that I was putting in talked about getting money to seniors so they could stay in place. And also it had to do with landlords of 5 or less. And in that provision, we had agreed that there would be caps. While we didn't want to keep it at 3%, we moved it up to 10, but there is a vein to follow with that. It's not exactly the answer, but it's close.
Sounded me that Senator Watson.
He wants to add the amendment. Just
Adding
that
the amendment.
one is, this is about mobile.
This is
home
about mobile
communities.
homes, not about
One is
rental
about
properties.
Rental or condo units.
Correct.
So
This is different because they're actually buying the property. Which is otherwise without the mobile homes is a vacant lot. That's improved upon. I mean, they get So it's a little different. I understand what you're saying, and I think that's something to look into, and I think that's a noble.
This committee right now that is a vehicle to help do the exact same thing that this gentleman is trying to do, which I appreciate. I think it's a great, I think it's a good idea. I just don't want that tool to be lost in just one set of.
I think that this
homeowners.
bill, if it passes in this framework, would help your endeavor or your intention moving forward for a like bill for what would otherwise be a property that goes upward instead of a property that is actually a squared finite footprint of open land other than these mobile homes being there. Because what ends up happening is they're buying the property and then they want to redevelop it or do something else. So the intent behind it is being structured or shifted. And that's what we're trying to say is like, look, you can come in here and buy it, but you have to give these people before you evict them all, that they've got to be able to have the opportunity. So a like circumstance that you're talking about, and this is why it's different, is you're just focused on that the rent part. If they leave it as a mobile home park, and Bill, correct me if I'm wrong on that. And then if, we would have to be saying that someone's coming in, buying the property, and their intention is to destroy the property, the building within so many years and make it a Costco tire, parking lot. So that would give them the opportunity, instead of losing their rights to be able to stay and have that building as their home, the apartments or the condos, that they could all band together and buy the property so that Costco couldn't come in.
Where people purchase the property is a multifamily unit. They will tear that property down, displace all these families, build another apartment building on it, but put a Safeway at the bottom of it. And so these folks are displaced, but they don't have those same tenants don't have the ability to purchase the property of the rights of first refusal, which you're trying to put in this bill, or the cap and rents for a certain amount of time either.
Yeah, I would say two things. I mean, the way it works for mobile home parks, this lease is much more commensurate or similar to a ground lease rather
Yes.
than just an apartment. Because this is, as Senator Folden pointed out, property that you both own, and then there's a lease attached to the ground. So it looks a lot more like a ground lease than it is an actual rental apartment.
I hear Senator Washington's suggestion. It sounds to me like that has to be a separate bill. I mean, rent control over a large swath of Prince George's County will affect a lot of people, including landlords. They have no knowledge about that. And we need to have a separate bill which would allow anybody who is affected by that to come in and testify.
Wanted to also just alert the committee and you, Senator Washington, I really respect the issue you're dealing with, but mobile homes, this is not real estate. Mobile homes are personal property. They're treated very differently, and they can be moved off the property. And oftentimes, not always, the tenant owns that mobile home. So just the dynamics of how they're created and how they can be uncreated is really, really different from brick and mortar buildings. That's just a little bit of difference there that you want to take into account.
Chairman is, I know how mobile homes work. I understand this. And it's not offensive. I appreciate the background. But I would just say that if we're setting a precedent of capping rents, and we're setting a precedent of rights of first refusal for people to band again together, I just hope that we will consider that moving forward and from this committee. So thank you.
Can we adopt the amendments? Is everyone okay adopting the amendments? All right. No, sorry. All right, that's okay. Now the bills before you as amended. Motions were favorable and seconded. Is everyone okay being recorded in the affirmative? All right, excellent. Two-two-seven.
Senate Bill 227 expands provisions of state law governing the treatment of abandoned vehicles, including provisions related to reclamation by secured parties and cost recovery by police departments for the impoundment, storage, and sale of such vehicles to apply to Anne Arundel County and municipal corporations within Anne Arundel County. We do have a delegation letter from the Anne Arundel County delegation for the bill.
Favorable, it's been seconded. Is everyone okay being? Sure.
Just for the record, not only is 227 famous television show and this bill number, it is apparently the new area code for Maryland. So when we run out of 240 numbers and 410
It's
numbers,
gonna be 227.
we got 227 on the way.
Hey,
So in honor of that, I will make a favorable motion.
yeah. I still have a 301 number. What? I'm kidding. Yeah, it is. Yeah, yeah. All right. Motion, the bill passes unanimously. All right. Seven ten. Jill, you can ask for it.
Senate Bill 710 expands the circumstances under which a report or record concerning child abuse or neglect may be disclosed to specified school personnel or to the director of a licensed child care facility or licensed child placement agency. So to be specific, currently these reports are disclosable to school only when it concerns abuse committed against a student by an employee of the school. This would expand it to also include reports of neglect and reports of abuse and neglect concerning non-students. Currently, these reports and records are disclosable to child care and placement agencies only when the report concerns an employee of the agency, and this would expand it to include reports of abuse and neglect concerning any person who was in the custody of the agency or any person who was approved by the agency.
Motion for favorable has been seconded. Is everyone okay being recorded in the affirmative? All right. Senator Carter's no. All right. Bill passes 10-1. So no, sorry, not 10-1. And where did Bill, Shamar's last one, Senate Bill 288.
Senate Bill 288 creates exceptions to criminal prohibitions against trespass on property under Title 6, Subtitle 4 of the Criminal Law article, and the common law tort of trespass for a professional land surveyor or an agent or employee of a professional land surveyor who enters the property of another to practice land surveying.
Motion's been for favor, motion seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 288 passes unanimously. Well,
That's not unanimous.
not unanimous, but 7 to whatever,
9-2.
92. All right, that's it.
Well, 9-2.
9 to 2 excused. We are voting later today.